நீங்கள் பார்த்து கொண்டிருப்பது உங்கள் RSKV யூடியூப் சேனல்.
Income Tax Officers Exam 2016, Paper 3 Allied Laws. As per Companies Act, the financial year shall not exceed, it's question number 1, 18 months with special permission from Register of Companies. Number 2, which of the following reports should have responsibility statement under the Companies Act? Board of Directors report. Third, the portion of share capital which can be called up only on winding up of a company is known as reserve capital. 4, which of the following is eligible to issue shelf prospectus? Any public financial institution. In case of reduction in number of members below statutory limit, a company can carry on business for a maximum of 6 months. Number 6, XYZ Limited has 15% of share capital held by another company, XL Limited, with 50% held by central government, 10% held by state government, and 25% held by general public. The company is a government company. 7, the number of persons in any association or partnership other than a company within the meaning of the Companies Act shall not exceed such number of persons as may be prescribed, subject to a maximum of 100. Number 8, what is the maximum limit of remuneration for a whole-time manager in a company? 5% of net annual profit. Number 9, the audit committee acts in accordance with terms of reference specified by Board of Directors. The dividend declared between 2 annual general meeting is known as interim dividend. Number 11, a company can forfeit shares allotted to a shareholder if the shareholder fails to pay the call amount in stipulated time. The maximum period of redemption in case of preference shares issued by a company is 20 years, 20. Number 13, the first annual general meeting of a company must be held within 9 months from the close of first financial year. 14, which of the following companies do not have the obligation to get its articles of association registered along with the memorandum of association? Answer, public company limited by shares. Number 15, an innocent promise collateral to the main illegal promise shall be regarded as illegal promise. Number 16, A promise to pay B a certain sum of money on a certain date. A dies before the time appointed for promise. What is B's remedy? A's representative can be forced to perform the promise. 17. The rule of promissory estoppels implies estoppels implies an act done at the desire of the promissory furnish a good consideration for his promise and he becomes bound by his promise. Number 18. Where a person lawfully does anything for another person, not intending to do so graciously, and such other person enjoys the benefit thereof the person, gratuitously, and such other person enjoys the benefit thereof other person, is under obligation to make a compensation for this benefit. Number 19, an advertisement inviting tender is an invitation to offer. 20, change of nature of the obligation in a contract is known as novation, Novation. 21, a voidable contract can be cancelled under section dash of the Indian Contract Act, 64. Number 22. In which of the following cases an agreement shall be absolutely void? When both parties to an agreement are under mistake of fact essential to the agreement. At what place contract concludes when acceptance is given by telephone? Answer: where the acceptance is received, heard, and understood. Number 24. What is a promise? When both parties exchange their offers. 25. Every promise and every set of promises forming the consideration for each other is called an agreement. Number 25. Every promise and every set of promises forming the consideration for each other is called an agreement. 26. A lunatic sells his property to B for rupees 10 lakhs during one of his sane intervals. Before B could take possession of the property, A again goes into the stage of insanity. Which one of the following is correct position? The answer: the contract is valid and enforceable. 27. The basis of doctrine of frustration is that the performance is excused where a fundamental assumption underlying the contract has become impossible. 28. Only such damages are recoverable for the breach of contract as arise naturally in the usual course of things. 29. When the injury is so grave that the damages cannot be assessed, the injured party may be awarded by court exemplary damages. 30. The members of a trading joint family may agree to be partners in a separate business by dissolving their joint family. 31. If an expression used in the Partnership Act 1932 is not defined therein, it shall have the same meaning as assigned to it in the Indian Contract Act 1872 if defined therein. 32. Within how many months of attaining majority or obtaining knowledge that he had been admitted to the benefits of partnership, whichever date is later, is a minor required to give public notice that he has elected to become or that he has elected not to become a partner in the firm. Answer: 6 months. 33. There can be a valid partnership between A, the Karta of the HUF representing the HUF on the one hand and a member of the HUF in his individual capacity. B, between two firms. C, a Muslim or a Christian family members carrying on the family business. Answer: 1 and 3. 1. The Karta of the HUF representing the HUF on one hand and a member of the HUF in his individual capacity. Third, a Muslim or a Christian family members carrying on family business. These two are correct. Number 34. Which of the following statement is true? No person can be a partner in a valid partnership firm unless he has the right to share the profit of business. Number 35. Partnership at will means where duration of the partnership is not specified. 36. The concept of holding out as per section 28 of the Partnership Act 1932 means a misrepresentation by somebody as a partner of the firm. 37. Under the provisions of section 6 of the Transfer of Property Act 1882, the chance of an heir apparent succeeding to an estate, the chance of a relation obtaining a legacy on the death of a kinsman, or any other mere possibility of like natures cannot be transferred. Number 38. The term transfer under the Transfer of Property Act 1882 refers to A, partly or whole transfer, B, absolute or conditional transfer. Both A and B are correct. 39. Under the provision of Section 9 of the Transfer of Property Act 1882, the transfer includes both oral and legal transfer. Number 40. In the Transfer of Property Act 1882, Sections 44 to 53 apply to immovable property. 41. In which section of Transfer of Property Act 1882, right to proceeds of revenue, sale or compensation on acquisition is defined? Section 73. 42. In which section amendment has been made in the Transfer of Property Act 1882 by the Transfer of Property Amendment Act 2002? Section 106. Question 43. For making a gift of movable property, the transfer must be effected A. through a registered instrument, B. through delivery. Both A and B are correct. 44. In which section of Transfer of Property Act 1882, part performance of a contract is defined? Section 53A. Question 45. A executed a bond in favor of B under circumstances entitling the former to have it delivered up and cancelled. B assigns the bond to C for value and without notice of such circumstances. As per Section 131 of the Transfer of Property Act 1882, C cannot enforce the bond against A. The statement is true. 46. Section 58 of the Transfer of Property Act 1882 defines and includes which of the following? A. Mortgage, B. Mortgager, C. Mortgagee, D. All of the above. Answer D. All of the above. Question 47. As per Section 53 of Transfer of Property Act 1882, every transferred immovable property made with intent to defeat or delay the creditors of the transferee shall be voidable at the option of any creditor so defeated or delayed. The statement is true. Question 48. As per Section 107 of Transfer of Property Act 1882, if a lease agreement is neither registered document nor an oral agreement accompanied by delivery of possession, it cannot create lessor and lessee relationship. Please state that the statement is true. Question 49. Competent authority for RTA Act 2005 in the case of Council of States or Legislative Council of State is the chairman. Question 50. For the purpose of subsections 3 and 4 of Section 4 of RTA Act 2005, disseminated does not mean making known or communicating the information to the public through public meetings. Question 51. Where an application for information or appeal is given to a Central Assistant Public Information Officer or State Assistant Public Information Officer, as the case may be, a period of how many days is added in computing the period for response specified under subsection 1 of Section 7? 5 days. Question 52. If the Central Public Information Officer or State Public Information Officer, as the case may be, fails to give decision on the request for information within the period specified under subsection 1 of Section 7 of RTA Act, the Central Public Information Officer or State Public Information Officer, as the case may be, shall be deemed to have refused the request. Question 53. Notwithstanding anything contained in RTA Act under Section 8, there shall be no obligation to give any citizen A. Information received in confidence from foreign government, B. Cabinet papers, C. Information the disclosure of which would cause a breach of privilege of Parliament or the state legislature. Answer D. All of the above. Question 54. Within how many days of the enactment of the RTA Act 2005 does the particulars of its organization, functions and duties have to be published by the public authority? 120 days. Question 55. Central Assistant Public Information Officer or a State Assistant Public Information Officer, as the case may be, have to be appointed at each subdivisional level or at the sub-district level within 100 days. Question 56. Where the information sought for concern of the life or liberty of a person, the same shall be provided within what period of the receipt of the request? 48 hours. 57. As per RT Act, information can be sought directly by a citizen of India. 58. Subject to the provision to subsection 2 of section 5 or the proviso to subsection 3 of section 6, the Central Public Information Officer or State Public Information Officer, as the case may be, on receipt of a request under section 6 shall be expeditiously as possible, and in any case within how many days of the receipt of the request, either provide the information on payment of such fee as may be prescribed or reject the request for any of the reasons specified in section 8 and 9. Answer B. 30 days. Question 59. What period for the purpose of calculating the period of 30 days is to be excluded where a decision is taken to provide the information on payment of any further fee representing the cost of providing the information by the Central Public Information Officer or State Public Information Officer, as the case may be. Answer. Intervening period between the dispatch of said intimation and payment of fees shall be excluded. Within what period shall a Central Public Information Officer or State Public Information Officer, as the case may be, when he intends to disclose the information or record or part thereof, invite the third party to make a submission in writing or orally regarding whether the information should be disclosed? 5 days. 61. Under section 4 of 1 bar B, X of the RTA Act 2005, the monthly remuneration received by its officers and employees, including the system of compensation provided in its regulations, have to be provided in respect of each of its officers and employees. Number 62. Upper limit for the number of PIOs and APIOs to be appointed by the public authority as per the RTA Act 2005 is no upper limit. 63. Below are given definitions, meanings of certain terms used in the Smritis to define different types of Stridana. Identify the incorrect definition. Pritidatta. Gifts received in token of love by a woman through affection from a father-in-law or mother-in-law. B. Adhyagni. Gifts received by the bride before the nuptial fire. C. Podavandiga. Gifts made to a woman at the time of her making obeisance at the feet of the elders. D. Adhyabhanika. Gifts made to a woman at the occasion of birth of her first son. Identify the incorrect definition. Adhyabhanika is wrong. Gifts made to a woman at the occasion of birth of her first son. Number 64. As per Mitakshara law, the property categorized under Sapratibandha Dhaya or obstructed heritage would not include the property inherited by a Hindu from his father. Number 65. A joint Hindu family firm as against a partnership firm is not characterized by one of the following features. Identify it. Answer. Dissolution in case of death of a co-partner or member. 66. The term propinquity refers to the governing principle in Mitakshara law for determining the right to inheritance. 67. Which of the following statements is true regarding the rights of a woman in a Hindu joint family? After the enactment of the Hindu Succession Amendment Act 2005, a Hindu daughter, also like sons, has been given the right to become a co-partner. 68. In Hindu law, the term codicil refers to an instrument made in relation to a will. 69. The term Adivedantika, used in a relation to a Hindu woman's Sridhana, refers to gifts received by her from her husband on supersession, that is, on the occasion of his taking another wife. Number 70. Identify the correct match. Dhayabaga Jimuta Vahana. Then number 71. Identify the incorrect match. 71. Identify the incorrect match. Answer. Right to property arises to the dash Dhayabaga, law claimant by birth and not by death of the last owner. Number 72. What is the number of days within which a defendant may appear and file the written statement upon issue of summons? 30 days. 30. Service of affixture requires that defendant is absent at residence and is unlikely to be found there within a reasonable time. B. There is no agent empowered to accept service of summons. C. The service officer has carried out due and reasonable diligence to find the defendant. Answer. All of the above are correct. Number 74. The travelling and other expenses of the person summoned is defrayed at the expenses of the party applying for summons. Number 75. The court may compel the attendance of any person to whom a summons has been issued, and for that purpose it is not empowered to send a court officer to bring him by reasonable force. Number 76. Application for execution of a decree is to be made to the court which passed the decree. 77. An executing court cannot determine the questions relating to which of the following: modification of decree. In case of 78, in case of a joint decree, the execution must be applied either by one or more or all the decree holders. Number 79. Maximum period of detention in civil imprisonment where the decree is for more than rupees 2000 but less than rupees 5000 is 6 weeks. Number 80. Under section 78 of the code, the commission can be issued for the examination of witnesses by or at the instance of A. Court situated in any part of India to which the provisions the code do not extend. B. Courts established outside India by the authority of the central government. C. A foreign court. Answer. All of the above. 81. Order 5, Rule 9 of 3 of the code provides that service summons to the defendant cannot be served through short message service SMS. Number 82. Where the defendant resides out of India, the summons shall be addressed and sent to him under Order 5, Rule 25 of the code through post. 83. A civil court cannot issue commissions in the following case: D. To execute a decree. Number 84. While determining sufficient means of a person property exempt from attachment in execution of a decree is to be excluded. Number 85. An executing court can go behind the decree where A. The decree has been passed without jurisdiction, pecuniary, territorial or subject matter. B. The decree is utility having been passed against a dead person without bringing his legal representatives on the record. C. Where the decree is ambiguous. D. Answer. None of the above. Question 86. Which of these is not necessary for constituting a partnership? Written contract. Number 87, A, B, and C are partners in a firm. On A's death, public notice of death is not given and the firm continues the business. In such case, for acts of the firm done after his death, A's estate is not liable. Number 88, A and B agree to share profits of a business equally, but any loss would be borne by A alone. The partnership is valid. 89. A and B enter into no agreement to prepare Mumbai-Pune Expressway. The partnership comes to an end after preparing the expressway. This arrangement is called particular partnership. Number 90, for all acts of the firm done while he is a partner, each partner is jointly and severally liable. Number 91, a partner may be expelled from the firm by majority of the partners. Number 92, a minor can be admitted to the benefits of dash with the consent of all partners, existing firm only. 93, a police station to deal with cyber crimes is to be opened. Who can be the in charge of the police station? Deputy Superintendent of Police. 94, electronic gazette is another form of gazette notification. 95, Section 6, 7 and 8 of the Information Technology 2000 dash right to insist that a document be accepted in electronic form. Do not confer. Number 96, the expression signed under Chapter 3 of Information Technology Act 2000 means affixing of handwritten signature or any mark on any document. 97. E-commerce is the commercial translation of service in a or an electronic format. 98. Information under Information Technology Act 2000 includes A. Sound, voice, codes, computer programs. B. Data, text, images. C. Software and database, or microfilm or computer generated microfiche. Answer D, all of the above. Number 99, a person indulging in backing is punishable with imprisonment up to 3 years or with fine which may extend up to rupees 2 lakhs or with both. 100. Income tax returns are e-filed because Chapter 3 of the Information Technology Act 2000 provides legal recognition for it. Answer. Over.